we have as the first order of business, we have the welcoming words by our dean, Professor Brigitta Zöchling-Jud, and I'm very glad and honored that you're here. Please, Britta.
Thank you. Yeah, dear colleagues. The welcome words by the dean. On behalf of the law faculty of the University of Vienna, I would like to welcome you to today's conference. The topic chosen by the organizers is more topical than ever. The future of cooperation between the EU and the UK raises numerous legal questions that not only require sound scientific analysis, but also still have to prove themselves in practice. I would like to thank my colleagues, Thomas Jaeger, Matthias Lehmann, Alexander Sommek, and Michael Weibel for taking the initiative to organize this meeting. And I'm sure you will have exciting presentations and very interesting discussions over the next 2 days. And I wish the meeting every success. Thank you.
Thank you very much, Britta, for being here, and thank you for opening the conference.
Good.
I will also not spare you some opening words. Thank you. Goodbye. You've heard the words. We're co-organizing the conference as a joint effort of our Institute of European International and Comparative Law. So the colleagues are here, Matthias Lehmann, Michael Weibel, Sascha Sommek over there. Also, the speakers are there. I welcome you who have made their way to Vienna Law Faculty in person today. I also welcome those who join us online at the conference Consolidating Brexit. And while I mention those who join us online, let me also please remind you that we do record the proceedings of the conference. That includes your interventions if you participate in the discussions. And also, I have the pleasure not just of welcoming you on behalf of the conference co-organizers, co-hosts, but also on behalf of our sponsor, Schönherr Attorneys at Law. It is in particular for their generosity that we are able to offer you, or at least those of you who are here in presence, coffee and snacks. Some of you have already grabbed some coffee, and also a warm lunch. So the lunch break is in principle, unless you want to head out, it's in principle also something that will take place here. I will not say too many introductory words about the topic of the conference. The topic speaks for itself. Maybe you have a similar feeling as I do that Brexit, even 6 years after the referendum and all the, I looked up the timeline on Wikipedia. There's so many different events, and it's actually hard to trace what happened, when it happened, and it's even more difficult why it happened. So it still feels kind of unreal, at least to me. But today's effort and also tomorrow's effort will be to retrace those events, try to make sense of the legal regime that was born out of Brexit, but more importantly, even to look forward. So to try to draw conclusions that will inform us about the future relationship between the EU and the UK, and also repercussions on the EU law and the future of EU integration. So I'm very happy that we brought those different fields together: comparative law, international law, European Union law. We also have political science among us. And I think, like the Dean said, this will provide for, it will warrant interesting, fruitful discussions to which I very much look forward today and also tomorrow. With that, I suggest we start immediately into the first panel. You will be seeing more of me this morning and also in the first panel of the afternoon. I will be chairing the first three panels. And may I ask the speakers of the first panel, that is entitled to The Agreements and has the purpose of portraying an outline of the agreements, but also of the events that led up to the agreements. May I ask those speakers to the podium, please? And while you settle, I will briefly introduce the two speakers. We will have the presentations in sequence, and then I propose we should have a joint discussion. The first speaker that I'm very proud and honored to welcome here and introduce to you is His Excellency Magister Gregor Schusterschitz. He is the acting ambassador to the EU at the permanent representation of Austria in Brussels. He's also the Austrian delegate at the Coreper and has been an active diplomat for decades, since the mid-90s. And he's also a very prolific author, also in a commentary that I co-edit with another colleague from the university, but much beyond that, also beyond the field of European law proper. He also is active in, or he's an active publisher in public international law. But even that is not the reason we invited you here. We invited you here because you were dubbed, and I think rightly so, as Mr. Brexit by the Courier and other journals, because you, between 2017 and 2019, His Excellency was the Austrian delegate to the Brexit negotiations, so right in the hottest phase of Brexit. So we're proud and honored for you to be here, and we look forward to your presentation. The speaker after His Excellency Ambassador Schusterschitz will be Magister Ulrike Köhler. She too has been an active diplomat for years. She's currently legal advisor at the Austrian permanent representation to the EU in Brussels. In particular, and that is also part of the reason why we're very proud and very honored for you to be here. She is Austria's representative in the Council Working Party on the United Kingdom. So the best placed person to tell us about the current legal regime and current legal qualms and issues. And I'm also very proud to say that before you, many years ago, not too many years, some years ago, you joined the Austrian Foreign Service. Before that, you were also a member of our faculty of the Department of Public International Law, and that was a path that then immediately prompted your career at the Austrian Foreign Service, if I may say so. So. Like I said, I'm glad and proud for both of you to be here. And I would like to invite His Excellency Ambassador Schusterschitz to give his presentation first on the negotiation, post-negotiation dynamics and challenges. Ambassador, you have the floor. Thank you.
Yeah, thank you very much. And also thank you very much for inviting me to this conference. As you said correctly, Brexit was an important part of my life for 2.5 years. Since then, I have moved on to other areas, which was also not bad, because Brexit was an incredibly interesting experience. But of course, it was a strange experience, because normally we diplomats are used to building a better future and not building a worse future. And the Brexit negotiations basically meant making future worse to what was before. That's why it was a very strange experience, but of course also very interesting, I have to admit. I will speak about the negotiation processes. There were 2 of them. one for the withdrawal agreement and the other for the trade and cooperation agreement, so the future relationship. And I will structure my presentation in 3 parts. First, I would like to shortly recapitulate how this 2 negotiation processes went. Then I would point out the similarities and differences between the 2 processes. And then in a last chapter, I will also discuss how the dynamics within the EU and also between the EU and the UK changed. As I said, there were 2 negotiation procedures that were very much different, but have striking similarities, we must say. First, we had the negotiation for the withdrawal agreement, which took place between July 2017 and November 2018. And then again, between September and November 2019. So here you had 2 phases, and I will mention them later. Second, the negotiation for a comprehensive trade and cooperation agreement and 2 other agreements on classified information and nuclear cooperation in the year 2020, when the future relationship was discussed. The interesting fact here is that during both negotiation processes, the UK was still part of the EU legal order. When we negotiated the withdrawal agreement, they were still a member of the EU. And when we negotiated the trade and cooperation agreement, they were not member of the EU anymore, but the EU law was still applicable in the UK. So first, the negotiation for the withdrawal agreement. There we can see 5 phases. As Professor Jaeger said, in 2016, we had the referendum on exiting the EU with a very, I would say, a clear majority. So there was a clear public wish to leave the EU, because also the participation of the electorate in the referendum was quite high. So it has some kind of democratic legitimation, it has to be said, even if it was for different reasons. So why do we have Brexit? We have Brexit because we have problems within the Tory party. And this is something that you can see in the whole process. What we are dealing with are problems within the Tory party. This is all that matters, and this led to the whole procedure. And we can see it until now, that problems you have in the relationship with the EU and the UK and all the issues are always problems within the Tory party. So then in March 2017, they lodged their wish to leave the EU, and then in accordance with the Article 50, they would have to, so that would enter into force 2 years later, so March 2019. So when the UK notified their wish to leave the EU, the process basically started also within the EU and not so much within the UK, because the UK had the wish to leave, but they had no clue what they really wanted, except for leaving. Whereas the EU very early on made a list of topics. Okay, this is important for us. This is what we want to achieve. These are our political aims. And the UK never really voiced clear political aims. And I will mention that later on. This is one of the problems of the negotiation process. So that was the first phase. There were 5 phases of negotiation for the withdrawal agreement. The first phase was from July until December 2017, where we said, okay, we have the big political topics and we want some kind of political idea on where we're heading on those topics. And this was citizens' rights. This was a very important issue. Now we had 3 million EU citizens in the UK and about 1 million UK citizens in the EU. So how do we deal with them? Because they moved to the UK or to the EU, basically under the idea that this is travel, or this is free movement of persons within the EU. And now suddenly there would be in different countries. So here it was very important to regulate the status of the citizens. The second is financial issues. The multi-annual framework until 2020, of course, was also done under the presumption that the UK is a member of the EU. And then the third topic, and this is until now one of the most important and political hot topics, is Northern Ireland. So then we said, okay, we have these three topics, we want to discuss them. So what do we do with those? And then in December 2017, there was a joint report by the Commission and the UK on how to deal with those issues. Then the next phase was basically between January and March 2018, where this political agreement in the joint report on these main issues was put into treaty language. And also an important political decision was taken in that phase. That is that even when the UK leaves, we will have a transition phase. So that they have left, but then the acquis communautaire would be applicable for a longer time. Then the next phase was from April until November 2018, where basically the whole withdrawal agreement of 300 odd pages was negotiated. And this is very important, also a political declaration was negotiated on the future relationship. Some kind of, as an international lawyer would say, a pactum de contrahendo, that we set out the basic parameters for the future negotiations to ease also the future negotiations. And then it's also, of course, easier to negotiate the withdrawal agreement when you have an idea what comes next. Then after November 2018, we entered into a very difficult ratification phase that basically lasted from November 18 to July 19, where the British government tried to get the agreement through in the House of Commons, which failed several times. And the biggest worry within the House of Commons was basically the Northern Ireland solution, because the idea was that for the time being, the UK would stay part of the customs union, and then in the future relationship, we would try to find something else. And many members of the House of Commons feared that this interim solution would last forever, and then they would never be able to leave the customs union, and all the big talk about global Britain and sovereignty and so would then for naught. So that's why there was this big problem. Then we tried to negotiate additional political declarations that we want to have that phase as short as possible. We want to replace it by a final solution, so on. But still, it never worked, and it was never approved in the House of Commons. Then Prime Minister May said, "Okay, if you don't accept my agreement, so what do you want?" So they had indicative votes in the House of Commons in April 2019. And in these indicative votes, they had like 5 or 6 different options how to do Brexit, and none of those options gained a majority. So as I said here, the UK never knew what they really wanted. That was the problem. And all of those options were then rejected basically by Parliament. And this then led to the downfall also of May as Prime Minister. And then we had Boris Johnson coming in the summer of 2019. And then basically negotiations took up again. And then we had the last phase that we renegotiated the withdrawal agreement that was already on the table for several months from this September until October 2019. And the big thing here was that the Northern Ireland Protocol was changed. So again, the hot political issue that the UK would leave the customs area, but Northern Ireland would stay in, which means that you have customs controls in the Irish Sea between Northern Ireland and Great Britain. But through that solution, Boris Johnson could then conclude his own trade agreements. That was what he always wanted, and he didn't have to stay in the customs union. Yeah. So and then the agreement basically was agreed. Was signed in December 2019 and then provisionally applied when UK left the EU on the 31st of January 2020. So then the UK was out with a transition phase until the end of 2020. And this gave the time to negotiate then the agreement on the future relationship, because we never knew what will be the future relation. Will there be a customs union? Will there be a trade agreement? What will the cooperation in foreign policy and so on be? Then in March 2020, we started the negotiations for the future trade and cooperation agreement. And this negotiation process had basically 3 phases. The first one was from March until June 2020, which was the most difficult phase, because this was at the height of COVID. You might remember this pandemic that we had. This was the worst, of course, for negotiation processes and diplomatic life, because there's nothing you can really negotiate in video conferences. That's why this phase basically only deteriorated the political relations. And it was clear that, you know, in that circumstance, we will never have an agreement. So then they said, okay, we need to have a new input. And then there was a high-level conference in June 2020, which gave a new impetus to the negotiation process. And very important was also that the EU negotiator, Michel Barnier, made very important compromises towards the UK, and therefore trying also to stimulate the whole process. So he accepted that there will be no dynamic application of EU law, something that we always wanted before, that the ECJ, the European Court of Justice, will not have a big say, and then also the question of fishing quota, that the EU has to accept that the fishing quota would be less than it was before, and the EU hoped that the UK would reciprocate by similar offers of compromise. This did not happen, so they basically took what the EU offered and then still insisted on their demands. That's why the second phase was also not as easy as one would have hoped. And the UK demanded very clearly that they want to discuss treaty language, something that we rejected, because we said we want an agreement first on all the issues, and then we can really discuss on treaty language. So that the fear always was that the UK would just take what they had agreed on the political issue and then not compromise on other issues. So there was this necessity also to keep things basically in the air. And then the intensive negotiation between October and December 2020, when then the treaty was really agreed. And it was always said, okay, we need an agreement by October 2020 so that we'll be able to ratify it. Then October 2020 passed and nothing happened. Then, okay, we need it by this, and it was basically always postponed. And then the negotiators of the Commission and the UK agreed on the 24th of December 2020, which necessitated a meeting of the member states basically the day after. So we had a COREPER meeting on the 25th of December at 10 o'clock in the morning, and I think this is the first time in the history of the EU that they had a meeting on Christmas Day. That's why it was also the Christmas COREPER, in order to agree on that agreement. Yeah, and then it was signed, and when the transition phase was over on the 31st of December 2020, the agreement was applicable. And these two negotiation processes are really interesting from various points of view, because you would expect to be at two different negotiation processes, because the legal basis was different. The withdrawal agreement was negotiated under Article 50 TEU, whereas the trade and cooperation agreement was then a normal agreement between the EU and a third country. So you would expect that, you know, it goes from that setting to another setting, and the EU is negotiating hundreds of agreements with third countries. And you would have thought that there's ample examples for that, and then we know our procedures. But the interesting thing was that the two negotiation processes were very identical even. Though they had a different political setting, a different legal basis, but still somehow it is such a special case that there were the same negotiation process, as you can say. And I will show that these common features in some examples. First important aspect was for also the procedure within council. And there we have a strong continuity of the working methods. And in 2017, when all this started, nobody had a template for it. So we had to invent new proceedings, how to deal with that issue. At one of the first meetings of our working party in April 2017, I was using the German word Neuland, because I didn't know what the English expression was. But this word then stayed for the whole process, and then our chairman always used the German word Neuland, because we had to invent all these proceedings somehow and how to deal with it. And the idea was that we have a special working party only dealing with the negotiations, and also that we have a permanent chairmanship by the council secretary, not by the rotating presidency. And this working party did everything alone. So it was a kind of a third core, you could say, because it was not done in other working parties, which deal with land transport or with social security issues. It was all done in that working party, and that was for both negotiation processes. So this is very a big difference to other free trade agreements where you discuss it in the technical working parties and not only in one. Also very important was that in both processes, it was the clear wish to have anonymity. Article 50 allows for qualified majority. But it was very clear from the beginning that we want basically anonymity. Everybody has to be on board. And also for the trade and cooperation agreement, we could have chosen Article 218 TFEU as a legal basis, but also here there was a clear wish that we want anonymity. And that's why the Commission proposed Article 217 TFEU as a legal basis, as an association agreement, something the UK was not happy about because they wanted to downgrade as much as possible this future agreement to have their ideas of global Britain and total independence, so on. And an association agreement even sounded too much like being still associated with the EU, but that was the legal basis that was chosen. Also, a feature that was true for both negotiation processes was a very strong cohesion among member states, among the 27. So we had this single negotiator principle. So it was Michel Barnier that negotiated both agreements. Also here, the personal continuity was really important. And then everything was done through him, basically. There were several attempts by the UK to instigate negotiations on a bilateral level with various member states. But yeah, we could use it, we could discuss it bilaterally, let's find an agreement. And there was clear, no, we don't do that. So we listen to you, but we don't negotiate. And if you want to have something, go to Michel Barnier and discuss it with him. There are no sidetracks. Another issue that was also true for both eras are the main political aims. So the aim, what to achieve, was similar in both processes. For the UK, it was full sovereignty. That was their thing. The whole thing was about gaining full sovereignty. It's an illusion, we know that, but that didn't prevent the Tory party from following that unicorn with Global Britain and all that slogans. Whereas for us, the most important thing was to preserve the integrity of the internal market and of the EU legal order. Because if you have somebody outside who can influence the legal order or who can, have incursions into it, then you have a problem with competitiveness, the level playing field. If you have a trading partner that can import goods into your area but doesn't have to follow the same rules for producing those goods. That's why, for example, governance was a big issue, how to preserve the integrity of the agreement, how dispute settlement system, and which organs do you have. And there was a big problem between, as I said, full sovereignty and the integrity of the single market. And these aims basically never changed, and this is a problem until now. Then also a common feature is that it was a very unique negotiation process, because normally when you negotiate an agreement, you try to increase convergence. That's the idea of negotiating agreements. Here it was the contrary. Here we had to manage future divergence. So we had total convergence, but they had to manage a future divergence. So this is totally different to all other basic ideas of agreements. Also, both negotiation processes had extreme time pressure. This is something that really, as I said, and then it led even to meetings during the Christmas holidays. As Article 50 has a 2-year time frame until it enters into force, because if you don't have an agreement within 2 years, then they just crash out without any agreement. This no deal Brexit. And so we had basically 1.5 years for a negotiation process nobody ever had before, nobody had any experience with. And it is extremely difficult to extract someone from this complex legal order EU. Somebody said it's like getting the egg out of the omelette. And then when it became clear that we wouldn't manage it, Brexit was postponed a bit. But then at a certain stage, also Prime Minister Johnson said, okay, that's it now. So we leave on the 31st of January 2020, and there's no further postponement. So here, extreme time pressure in order to avoid a cliff edge scenario. And this time pressure then was also kept for the TCA, for the Trade and Cooperation Agreement, because here we could have also prolonged the applicability of the acquis communautaire. But here Johnson said, no way, it will end on the 31st of January. That's why we had to do it very quickly. And this was this extreme time pressure that was true for both processes. Also, both processes had basically 2 phases. One of the striking features of the negotiating process was an incredible amount of transparency. And that was also the issue why we could keep the single negotiator principle, because Michel Barnier very openly also communicated to us how the negotiation went, and integrated the member states representative, was all the European Parliament, in the negotiation process. He was very transparent there. And through that, it was also transparent basically to the public. So you immediately knew what would happen when we had discussions in the Working Party, and then even the pound exchange rate changed based on the discussions within the Working Party, because it was immediately leaked what's going on there. So here it was an extreme transparent procedure in both cases. And then at a certain stage, people realized that this is not going to work like this. And you need a protected area of deliberation. That's why then the first phase was always very transparent. And then the last 3 months, there was so-called tunnel negotiations. So the Commission and the UK would go into a tunnel and would only emerge afterwards with an agreement. And this then was important for getting a compromise in both cases. Another issue that both processes was a very strong sense of parallelism, because as I said, the UK always wanted to get agreement by the EU on issues that were important for them. And once they had it, they would play hardballs on other issues. That's why we said we keep everything open until the very end. And only when we have agreement on all issues do we then put it into treaty language and then find an agreement, so that we can't, then we're not in a weaker position towards the UK than if we just give them what they want and then don't get anything in return. So this parallelism was a very important feature of the process. Another issue was that we had in both cases was the contingency planning, because everybody wanted to have an agreement in both cases for the withdrawal and then for the end of the transition phase, but nobody knew if it really would work. So what we did when we negotiated the withdrawal agreement is to have also EU legislation in place that if we don't have an agreement and if they crash out without an agreement, that at least we have rules internally on how to deal with UK issues of, for example, the status of citizens, traffic rights, and all those issues. And there we negotiated internally many 5 or 6 regulations that were never had to be applied. And then in the case of the TCA, they could use these templates, but also never had to use it, fortunately. And the last topic that I want to mention here is the Northern Ireland issue, which was the most difficult issue throughout the whole negotiations. It is clear that without Northern Ireland, I think everything would have been easier. But Northern Ireland caused an extreme problem because you have the Good Friday Agreement from '97, and one of the important pillars of the Good Friday Agreement is the economic cooperation, that there's no economic border between Northern Ireland and the Republic of Ireland. And this economic cooperation, of course, rests on the fact that both are parts of the internal market. And how to deal with each, because everybody knew that if you have customs controls on the Irish island, that 2 weeks later you will have bombings and you know what, and so in preserve the peace, Northern Ireland was a big issue. But you have to have customs controls somewhere. So either you make the customs controls at the UK border, and then goods can flow freely on the island, or you have it in the Irish Sea, or you have it on the island, or you have it between Ireland and the EU. But why? Because they're in common. So this was very clear that this is one of the most difficult issues, and I think is haunting us until now, because the basic idea of May was that the UK would stay for the time being within the internal market, and then we see how we deal with it. And then Johnson came and said, this is totally unacceptable. We need to have our own trade agreements. So then Boris Johnson had this idea, okay, then Northern Ireland stays within the customs area, basically, of the EU, and then you would have customs control on the Irish Sea within the UK. And that was basically his idea, and that was then put into the final withdrawal agreement. And then after it was signed, he said it's totally unacceptable. You can't have customs control within the UK, and we need to change that. And then we said, yeah, but guy, that's what you wanted. This was your idea. Now you don't know, yeah. But Boris Johnson is not. Yeah. So he's not the trustworthy partner, I think, as Theresa May was. So this argument didn't really fly with him. And then he even proposed the internal market bill in September 2019, which would enable the UK to break international law. This is also something that is quite interesting, I would say. But this is an issue that is haunting us until now. So you see, these are the similar issues on the withdrawal agreement and the TCA. And now I will just shortly also mention the issue of how the dynamics have changed in the negotiation process. As I said, Article 50 allows a third country negotiation process. So the negotiation as such were dealt with any other country, but UK was still a member of the EU. So this phase, of course, had repercussions also on the workings of the EU and the UK. When they were still a member, they didn't know what the outcome of the negotiation will be. So the UK, of course, was interested also in negotiations on EU legislation on internal market and so on, because they didn't know what their relationship to the internal market would be. So they wanted also to set the rules. And it was basically on that, and Boris Johnson said, okay, of course, we're interested in these rules, but we want to leave. That's why then when he became prime minister, he ordered all his civil servants to not participate in working party meetings anymore. And also in corporate, there were only in a very limited extent present. But of course, the problem was then how to find majorities for EU legislation, because you have the double majority with the Treaty of Lisbon. And if one big member state is missing, then it's difficult. Do you have a majority or not? So what happened in this phase that the council secretary basically had two votes So say, okay, if we have a vote with the UK, which would be the formal vote, is there a qualified majority? And then would we have a qualified majority also if the UK would have left already? And only if there are qualified majorities in both cases, would they then advise the presidency to go ahead so that the UK would not be able to influence the discussions, basically. But when then the UK left, of course, this double majority rule had repercussions on our internal workings, for example, and it led to a decrease of influence for smaller member states, interestingly enough. Because when you have the rule of double majority, you need the number of member states and you need the population criterion. And for us, smaller member states, so basically to have a blocking minority, we need us and we need some allies, but you need bigger member states also to have the population criterion, because it's very hard to get the numbers. This is a really high number that you have to achieve to have a blocking minority. And now we have basically one big member states less that we could incite to be part of a blocking minority. Now you have to have Germany or France, basically. And if you have not one of them, it's very difficult to have a blocking minority. And before that, we also had the UK. So you see that the UK leaving the EU increased the relative power of Germany and France and decreased the relative power of smaller member states. And you can also see it also on the content of EU legislation, that the EU does not have UK anymore. And there are three examples that I want to mention. First example is, for example, climate policy. UK was very important for the common EU climate policy, and you see that they're still very active. And the UK also managed to control some of those member states who think that climate policy is not necessary at all. For example, Poland. So the UK and Poland have a very strong relationship, also, coming from the war when Polish fighters fought at the Battle of India and so on. So this is very important for Poland, the UK as a partner. And there, the UK had a very positive influence also here. And this is something that we can see now. So Poland and other countries are much more adamant in their attempt to torpedo climate policy. With the UK not here. Another issue is the single market and trade issue. There are free traders, and the UK is always support a very strong single market. And now those countries who have the same opinions, like the Nordics and the Benelux, lost an important partner. And you see this relative decline of free trade and single market importance, but also with the whole concept of strategic autonomy that we have now. This would not have been possible, I think, with the UK still in the EU. And the third issue is a social policy. This is also where you can see, for example, we adopted a directive on minimum wage some months ago. This, I think, would not have been adopted if the UK would still be member of the EU. So you see here differences also in that respect. Yeah, and this is the situation that we have to deal with. And I have to say that all in all, it was very emotional, also not always positive, but nevertheless, we managed to agree on huge, far-reaching agreements. And this is also, I think, a very positive sign. And I think now we have come to grips a bit with the fact that they are a third country, but you will probably have better experience on that. And I think they still a special partner in many areas, but now they are a third country. And basically, we don't look back anymore. So within the EU, nobody talks about the UK, basically, except for your working party. So thank you.
Thank you very much, Ambassador, for this excellent presentation, just what we had hoped for. Now the floor is yours, Mrs. Köhler. And may I remind you that there is a handout for this presentation, also for other presentations. May I just quickly look around how many of you do not have it? Then we might still distribute it, but most of you have it. All right. Otherwise, it's where the registration desk is. Thank you. So, yes, please.
Dear Professor Jaeger, dear colleagues, ladies and gentlemen, thank you for the introduction. Indeed, I am currently the Austrian representative in the working party of the Council on the United Kingdom, and want to add with what is obvious, that I'm speaking in my personal capacity today. Still a remark on the Council Working Party on the United Kingdom. This refers to what Ambassador Schusterschitz has said before. The Council is still working very centrally on the United Kingdom. It's a system stemming from this negotiation process we just heard about. So it's not dispersed into many working parties, the different topics, but we have a very central look on it. So while we underline always that UK is a third country right now, there is still a special eye on this relationship, because it is special indeed. So my the title of my presentation is Overview of the Agreements, what's in, what's out, what's left. So I'll start with the what's in part. It's about 3,000 pages in 20 minutes. So I made handouts just with an unofficial table of the two agreements, withdrawal agreement and TCA, so that I have a bit of a structure when it should be easier to follow maybe then. Okay. Start with the withdrawal agreement. What's in the withdrawal agreement? It consists of 6 parts and 3 protocols. Going quickly through the parts. Part 1, withdrawal agreement. It's common provisions, contains standard clauses for the proper understanding of the withdrawal agreement. It contains definitions, territorial scope, but also a reminder to implement the agreement in accordance with the principle of good faith, which goes back a bit what Ambassador Schusterschitz just said. We remind sometimes about this principle of good faith when it comes to the current discussion nowadays on the Northern Ireland Protocol specifically. The Part 1, common provisions, also set out the relevance of judgments of the European Court of Justice for the interpretation of union law that continues to be applicable under the agreement. Part 2, citizens' rights. Ambassador Schusterschitz explained that this was a major part of the discussions under the negotiations, still continues to be a very important topic in practice. As was said, it's about 3 million EU citizens in the UK and 1 million UK nationals in the EU. The date of time that it's of relevance here is the end of the transition period, 31st of December 2020. So whoever has worked and was residing in the other territory has now the rights under the withdrawal agreement. And what's interesting is that the rights are there for the rest of their lives. People are beneficiaries of the withdrawal agreement under this part for the rest of their lives. There are still many questions to be resolved. We are working it on a daily basis, one can say. We are very busy with this. Family members are included also under this part. Security counts, so social security questions are also covered. Part 3, withdrawal agreement, separation provisions. It regulates what was going on mostly in the transition period, but not also between 1st of February 2020, but until the 31st of December 2020. So what to do with goods that were already on the market, what to do with proceedings that were ongoing at the time, what's to do with existing intellectual property rights, geographical indications, and so on and so on. But also with regard to ECJ proceedings, for example. Just to pick out one point, the Commission may bring infringement cases before the ECJ within 4 years from the end of the transition period, that is until the end of 2024 still, concerning breaches of union law, which occurred before the end of the transition period. But similar regulations, provisions are there for OLAF proceedings or administrative proceedings of the Commission. Part 4, transition. This is the part that covers the transition period. Ambassador Schusterschitz had already talked about it. The union law was still fully applicable to the UK between 1st of February 2020 and 31st of December 2020, while UK was not a member anymore and was no longer taking part in the institutions. And this was the phase that was used to negotiate the trade and cooperation agreement. Part 5, withdrawal agreement, it covers the financial provisions. It ensures that all financial obligations undertaken while UK was still a member state will be realized, will be fulfilled, will be honored. In particular, the multi-annual financial framework 2014 to 2020 and its programs. And it is the case that currently the UK still continues to pay its duties out of these obligations in a couple of installments per year. This part also covers what happens with assets in the European Central Bank, for example, or in the European Investment Bank. And then you have part 6 of the withdrawal agreement, institutional and final provisions. There's the governance structure set out there for the effective management of the agreement and dispute settlement mechanism. You have a joint committee that can deal with any questions that come up in the implementation application of the agreement. You have 6 specialized committees in place, the most active one being the one on citizens' rights, where all current issues are regularly discussed, and the dispute settlement provision that foresees political consultations, an arbitration panel, and also for questions of union law, requests are foreseen to the European Court of Justice to give preliminary rulings. But I think we'll have a panel on dispute settlement later in this conference. 3 protocols to the withdrawal agreements on Cyprus, Gibraltar, and Northern Ireland, which keeps us busy, as you know, and as you've heard just. What's in the Northern Ireland Protocol, Northern Ireland stays in the single market for goods. The union legislation on goods, sanitary rules for veterinary controls, agricultural production marketing, VAT, excise taxes, state aid rules are still applicable to Northern Ireland. Northern Ireland, as was said before, stays in the customs territory of the UK. At the same time, the union's customs code will apply to goods entering Northern Ireland, which, as was said, avoids customs checks and controls on the island of Ireland, but makes them necessary between Great Britain and Northern Ireland. What's also interesting, there is a consent mechanism in the Northern Ireland protocols. Every 4 years, the Irish Assembly can vote on keeping these rules or not. So we'll have the first vote in 2024, and after that, this voting, the referendum, will continue every 4 years. What's also in the Northern Ireland Protocol, what you always hear in the news, it's Article 16 of a Northern Ireland Protocol, which contains a safeguards clause. If one party thinks that the application of this protocol leads to serious economic, societal, or environmental difficulties, that are liable to persist or to diverse trade. The parties may unilaterally take appropriate safeguard measures. This is what has been discussed for a couple of years now, but never used in practice yet. So let's move over to the Trade and Cooperation Agreement. The TCA entered provisionally in force on the 1st of January 2021 and entered into force on 1st of May 2021. The original idea of the UK was to have several agreements on several substantive matters on the different aspects of the future relationship with the EU, but the EU argued successfully to have all the aspects covered in one agreement, which is the TCA now. So the TCA covers much more areas than a usual free trade agreement would cover. The TCA is structured into 7 parts. You can see that in the handout a bit more clearly to have the overview. Part 1 covers common and institutional provisions, like definitions, the institutional frameworks. You have common committees under the TCA, one partnership committee, one trade partnership committee, and around 20 specialized committees on different substantive aspects, plus several working groups. These committees and working groups keep working as of now and will keep doing so. Part 2 is the trade part, trade and economic aspects part of the TCA. It has 6 headings. It's about trade, aviation, road transport, social security coordination, fisheries mostly. So this is the FTA part of the TCA. Just 2 lines on the trade part. TCA foresees 0 tariffs and 0 quotas on all goods that comply with the rules of origin. What I understand is that this for example, goes far beyond the usual modern FTAs. It's a special feature. And was especially important for the European Union while negotiating the TCA is the level playing field part. So it's very important for the EU to maintain high levels of the protection of environment, but also to maintain social and labor rights, or state aid rules and tax transparency rules. So the level playing field parts sets out rules that either of the parties may not go be below a certain level that was there when the UK exited the Union. This was part 2 of the TCA. Part 3 of the TCA covers law enforcement and justice cooperation in criminal matters. You have rules on exchange of data, like the so-called Prüm data, passenger name records data, cooperation on operational information, cooperation with Europol, Eurojust, rules on surrender, mutual assistance, exchange of criminal record information, anti-money laundering, counter-terrorism, terrorist financing, and so on and so on. If one would not have this part in the TCA, one would have to use the rules of the Council of Europe conventions mostly, but that is So we are not back to this level, but have this special part 3 in the TCA. What's also important, part 3 has a special suspension clause. So if one of the parties would not comply with a certain level of fundamental rights or principle of the rule of law, there's a special possibility to suspend part 3 of the agreement, which is interesting when you follow the discussions in the UK on how to deal with rulings under the European Convention on Human Rights with the Strasbourg Court rulings. So part 4 covers so-called thematic issues of the TCA, notably health collaboration and cybersecurity. Then we have part 5 of the TCA about European Union programs about scientific participation. And part 6 of the TCA covering dispute settlement and horizontal provisions. So under the dispute settlement rules, I guess we'll hear about that in more detail. You have an consultations phases foreseen, and you have an arbitration procedure with a special arbitration panel in place. There's also provisions laid out about the common values of the treaty partners like democracy, rule of law, human rights, fight against climate change, fight against impunity, and so on. And then you have part 7 of the TCA with final provisions and also territorial scope, for example. There's a review of the TCA foreseen every 5 years. So the first review will take place 2026, and we will start preparing this 2025, most probably. Each party can terminate the agreement with 12 months notice. So this is the TCA main part, but this is accompanied by 49 annexes, 3 protocols, 14 declarations, and 2 other agreements on classified information and about nuclear cooperation. So this is trying to summarize what's in the agreements. Now I'm coming to the part what's out and what's left of the agreement. So this is a bit more of a brainstorming of mine. What's out of the agreement? Definitely foreign policy, external security and defense cooperation. It was envisaged to have foreign policy in the TCA. This was laid down in the declaration, in the political declaration of 2019, which was mentioned by Ambassador Schusterschitz. But the UK chose in the end not to have it in. UK prefers to work in other formats like NATO or G7 and not in the frameworks of the TCA. The TCA does foresee structured dialogues in some areas like trafficking of small arms and light weapons or fight against terrorism or cybersecurity. So structured dialogues are foreseen in these parts, but they are not happening yet. It's just not implemented yet. And then there are other areas that are not covered at all by the TCA, like sanctions or cooperation in the consular field. What is happening is an ad hoc cooperation and cooperation in other fora, of course. So what's out of the TCA also is decisions on equivalences of financial services, but also adequacy decisions on data protection regimes, also assessment of each other's legislation on sanitary and phytosanitary regimes. So there you have unilateral decisions on the equivalence, on the adequacy by each of the parties. What's out also of the TCA is the not out of the withdrawal agreement and the Northern Ireland Protocol regime, which is of course something that is an annoyance for some members of the Tory party in the UK. What's also out, UK is disconnected from all EU databases, including the Schengen Information System, and which changes a lot in the cooperation on the ground, and where we have to find new solutions to be able to work efficiently also in the future. What's out also is Erasmus Plus. UK did not want to participate anymore in the Erasmus programs, which is very regrettable from our perspective. The UK set up a unilateral scheme, which is not the same in our view for various reasons. What's also out, for example, is a solution for short-term travel for creative professionals. It goes under the title of touring artists. When UK bands or other artists wants to tour through Europe, they'll have to have a lot of paperwork for their visas, for the work visas, for the taking their equipments, their musical instruments with them. So it was even a letter sent by Elton John and Ed Sheeran to the UK government to find a solution for this problem. Also, there is no special rules for youth mobility, like student exchanges or au pair. There's not flexible rules here for these purposes. What's left? Left is definitely Gibraltar. Gibraltar is not in the territorial scope of the TCA. So the EU and the UK are currently negotiating an agreement about Gibraltar. The aim of such an agreement is to reach so-called border fluidity. So having goods and persons go to Spain and Gibraltar back and forth without any controls and checks, but still at the same time protecting the single market and the Schengen area, of course. Negotiations going on, some quite not so easy issues to solve yet. What's left also is a framework for financial services regulatory cooperation. There is a draft memorandum of understanding included in some of the protocol or annexes, but it's not signed or entered into force yet. So financial services regulatory cooperation. What's left, of course, is the implementation of the existing agreements. Some might think, as Ambassador Schusterschitz said before, we don't talk about the UK anymore. It's done. It's a third country. I cannot really subscribe to that. We are daily working on the implementation of the TCA. For example, under Part 3, new forms of cooperation, but have to be developed. We are working on a mutual legal assistance form to be adopted soon. The list of arbitrators under the TCA arbitration panel is not decided yet, but it's soon to be expected. There is a regulation and the preparation within the European Union on the exercise of the union's rights in implementation and enforcement of the withdrawal agreement and the TCA, meaning the following: in many parts of the withdrawal agreement, but also in particular of the TCA, you have suspension clauses or remedial measures, safeguard measures foreseen, rebalancing measures, compensatory measures foreseen. And if such a case might arise, who in the Union would take such a decision in implementation of the agreements? So, and this needs a regulation within the EU, and this is currently prepared, not there yet. Actually, so we're working on that. Then there's questions that could be worked on further and not yet fully realized from the TCA. For example, the association of the UK to the scientific programs like Horizon Europe, especially. There is regulatory cooperation foreseen under the TCA between the European Union and the UK, not going on as of yet. Of course, these structured dialogues in the foreign policy area not done yet. Then the TCA needs continued monitoring of everything that happens in the UK, especially in the fields of level playing field. We are monitoring what they do in subsidies, no subsidies bill, for example, no data protection bill of the UK, what they do under the human rights in the human rights part, because it is foreseen, it is to be expected in the future that the legislations will divert more, will get more and more different from the European Union. So this will have to be constantly monitoring over the next decades, I would say. And then there we also have still the monitoring the implementation of the withdrawal agreement, of course, where the biggest part is the citizens' rights parts. There are a lot of questions still to be solved what regards residence permits. There is legal proceeding going on currently before the UK High Court, where the Commission takes part. And we will be busy with that for many, many years to come. And of course, then there is the Northern Ireland Protocol. There are currently 7 infringement cases initiated by the Commission because the UK is not implementing the Northern Ireland Protocol. And then we have the pending the draft of a Northern Ireland Protocol bill currently in the UK Parliament. So we no longer talk about the Internal Markets Bill, but the Northern Ireland Protocol bill foresees the possible unilateral suspension of most parts of the Northern Ireland Protocol unilaterally and clearly in contradiction with public international law. So it's currently in the UK Parliament. We don't know exactly how the process is going on, if this bill will be ever passed, if this bill will ever get law, and when. So this is the big, also political open question, and including how the European Union will react then, if ever it comes to that. So, thank you.
Thank you very, very much, Mrs. Köhler, for so skillfully mastering the extensive agreements and preparing the ground for the rest of our discussion. It looks like the transmission has crashed, but it hasn't. It's just a monitor. We do have 15 to 20 minutes for discussions. That also applies to the people who participate online. Please, as you are, as is custom for Zoom meetings, just raise your hand and we will put you on the list of speakers. And when it's your turn online to speak, just turn on your microphone and we will be able to discuss with you. So the floor is open. Questions for both presentations, Professor Sommer, Professor Weibel. I'm collecting. And then from Meissner.
Okay, thanks. Thank you very much for these presentations. I have 2 questions. Um, Concerning possible participation of the UK in Horizon 2020 going forward, there's some say there is an issue linkage that has been made by the European Union with other aspects of this relationship with the UK, such as Northern Ireland. Do you see any prospect for the UK joining Horizon 2020 in the short to medium term? And the second question is, Mauritius and the United Kingdom announced last week they're going to negotiate a final settlement in respect of the Chagos archipelago in the Indian Ocean by early next year. Do you think this could have any repercussions on the ongoing negotiations concerning Gibraltar, in the sense that Spain may no longer be satisfied with just limiting these negotiations to issues of border fluidity and the like? Thank you.
Yeah, go ahead.
Okay. I have a question for Ambassador Schusterschitz, and I confess it's an entirely political question. I'm really interested in your perspective on this. You began your presentation by mentioning that it was the first time in your life that you didn't participate in a process that would lead to progress in the European Union, but rather to some form of retrogression that was unwanted. And I very much agree with you. It's unfortunate that the United Kingdom has left the European Union. But at the same time, you had to do something, and we're completely unprepared for it, of course. You had to create a precedent. And we now have, with these two agreements, a precedent. And I wonder whether this can become a bargaining chip on the part of the European Union when you're dealing with defiant member states. Member states that make it hard for the European Union to understand why they organize the judicial system in the way they do, or they adopt certain policies that we find appalling from a rule of law perspective. So I just wonder, isn't it good for the European Union that we now have an agreement and we can tell the Polish government, well, look, if you don't comply with the demands that we make on you in your judicial system, there's an alternative. We now have an alternative. I just wonder what your perspective is, whether it can be used for that purpose. Thank you.
Thank you. Dr. Meissner?
I'm the political scientist in the room. I also have two questions. One is, I was actually surprised that the trade and cooperation agreement was never considered or treated as a mixed agreement, given especially the political debate and the saliency surrounding the trade agreements negotiated beforehand, like CETA and the TTIP negotiations also. I understand there was time pressure, but I would be interested to hear if this was actually ever on the table or voiced by any member states to have that mixed agreement that would also require ratification by the national parliaments then. And the other question is on the issues that are out of the agreement, especially sanctions. That is now obviously a very important topic of the European Union. Is there any ambition or plan to enter into a dialogue or to potentially have a cooperation on sanctions, also because the UK was quite important in the area of restrictive measures for the European Union?
Thank you very much. I suggest we take a first round of answers while I collect questions and names for a second round of questions.
Yeah, thank you for the questions. I sort of expected the question on Horizon Europe. One thing you can say is there is no time limit in the TCA until when to associate UK to the Horizon program. The other thing I can say is, to my knowledge, there is no public statement of the Commission on future steps or next steps. So I guess this is the official announcement, not really an announcement. I mean, in general, one can say, I guess, for all, I mean, the TCA is a very broad agreement, which has possibilities to even more enhance the cooperation. There are several parts that are not filled with life yet. and Horizon is one of them. And I guess all of them are overshadowed by the general state of UK-EU relations. And those are mostly overshadowed by the situation in Northern Ireland in general. Mauritius, UK. This is Mauritius, UK as such is not a topic that we currently discuss in the council. There is on Gibraltar, there is a negotiating mandate proposed by the Commission, adopted by the Council on Gibraltar on this very narrow scope, border fluidity, which is already very complicated, including imports, exports, goods, checks, controls, airports, ports, and so on. I cannot see it opening up wider, and we have a lot to do with what it is now. So this is not it's not an issue. It's not never came up to change there, and it would be not so easy to change the mandate actually. That is given by the Council to the Commission to negotiate that. Mixed agreement, I leave it to you because it's part of the negotiating phase. And sanctions, of course, there are dialogues about sanctions, and I mean, it's not by coincidence that the G7 and the EU adopt similar sanctions. They only make sense if some of the biggest players adopt the same sanctions, but it's not foreseen under the TCA, and it's not foreseen as an official structured dialogues. There are dialogues, of course, but many of them are going on under the G7. And yeah, there are sanctions dialogues with third countries, also by the EU, but not under these agreements. I can say.
One word to Gibraltar. Gibraltar is a really interesting topic because at the negotiation for the withdrawal agreement, it was clear that you also need to regulate Gibraltar. And then suddenly Spain also saw the opportunity to take up the larger issue of Gibraltar. And suddenly everybody was Googling Article 10 of the Treaty of Utrecht of 1713. What does it mean on sovereignty on Gibraltar? Because this is really what Spain tried to do, to sneak in the notion of shared sovereignty over Gibraltar. And then some other countries were quite annoyed by that because it complicated issues incredibly. So we tried to have a group of friends of the Treaty of Utrecht, and we were part of that because we profited heavily from the Treaty of Utrecht. Naples, Belgium, and Luxembourg and Milan all became part of Austria with the Treaty of Utrecht. So, but it just shows how you then also some countries try to use the process also to settle old bills. Just as an anecdote on Gibraltar. The question if it is a precedent for future cases, I'd say yes, because everybody was horrified by this process and nobody wants to do that. So it's the best example to ensure cohesion also within the EU, I would say. And I mean, Poland is a difficult partner. Hungary is an even more difficult partner sometimes, but I don't think that they ever would want to leave the EU also because they profit financially so heavily from it. The contrast to the UK. UK was a large net contributor, but they are net recipients, and you could even see the dynamics, not on government level, but you can see it in the far right parties. So when you had the electoral campaign in 2019. The parties of the far right in the EU dropped the idea of exiting the EU. There was no discussion on Brexit, exit. I don't know. So basically, it solidified, I think, the EU because it's such a negative experience, and you can see until now how the UK suffers economically. I would say the Tories were lucky in the end because he had COVID. So they can say, yeah, all these problems that we have now is because of the pandemic. If they hadn't had the pandemic, then it would be really clear that all the economic disturbances that they have now are based on Brexit, which probably they largely are. Yeah, on mixed agreement, this is something that was ruled out from the very beginning as an opportunity. I mean, the Commission always tries to have less mixed agreement or fewest mixed agreement as possible. They would love to have all trade agreements also as union-only agreements. Several years ago, we had some sympathy for that idea, but for political reasons, we also now like more mixed agreement. But here, it was very helpful that, as I said, we have a different legal basis. We could have done things really differently, but everyone said, okay, let's continue. Let's keep the setting from the negotiation on the withdrawal agreement as much as possible in place and treat this as one process of negotiations. That's why I also was from the very beginning made clear that it should be a union-only agreement, and a mixity was never really requested by anyone.
All right, thank you very much. We have a last round of questions. So if you have pressing questions, please do ask them. Now we have Dr. Nudge and also a second speaker from the audience, and I may also, if I'm allowed, sneak in some questions at the end, and then I would close the discussion.
I would like to ask how are regulated the rights of workers, especially the free services between the United Kingdom of Britain and North Ireland, in according to the agreement on the withdrawal of the European Union and European Atomic Energy Community.
Thank you.
I have two questions. The first is on the TCA. You mentioned the judicial cooperation in criminal matters. And initially I was a bit astonished because I think for cooperating in civil matters is much easier for the state. So why is it left out? Or does it mean the cooperation within the Hague Conference framework is that much developed that you can rely on that, that you don't need specific provisions with Great Britain? And the second question is, you mentioned the European Court of Justice on the one hand, and on the other hand, other means of dispute settlement. I don't know whether this is part of panel 4, then we can leave it out. Otherwise, could you clarify a bit more what is still left for the court and what is now for the new dispute settlement framework?
Thank you very much. I see no further questions, so I'll sneak in my own. The first is to Ambassador Schusterschitz. I'd be interested in your take on the need for reform of Article 50 based on the experiences in the negotiation process. You mentioned special voting procedures, parallelism, mandate, member state control in the overlap to Article 218. So I'd be very interested in that. Another question goes to Mrs. Köhler, and that is about the enforcement of the agreement before EU and UK courts. How would you assess that enforceability? So is there direct applicability of the agreement in the UK? Are there cases yet? Is the agreement, can they handle that size and a vast agreement like that at all? What would you suggest, and is there any experience at all? And the third question to both of you, and then I'm done, is probably a little bit off topic, but it's on the foreign policy dimension that was left out, obviously left out of the agreements, and its relation to the European political community that was proposed and probably, we don't really know, at least I don't know, launched by President Macron. The UK was there. Do you think they were there because they didn't want to miss out, or what is the future of that European political community and the UK's role in it? Is that another form of cooperation integration that we will see in the future, or will it die off again? Thank you.
Excuse me for the short interruption. We also have 2 questions from online participants.
Please. Go ahead.
Maybe we do another question round?
No, okay. Yeah, maybe just one more question round, and probably the answers to this round right now. Sorry. Go ahead, please.
Okay, then I start with the need for reform of Article 50. I mean, it sets a very tight frame, and the biggest problem, I think, of Article 50 is this 2-year time period, and that was really challenging. But here, Article 50 entails necessary flexibility by the possibility to postpone it. The way we interpreted Article 50 now, I think, made it workable in 2 aspects. As I said, the time frame is important. And the other aspect that is important, that it's a catch-all competence. So we said that for the restricted area of withdrawal, we can regulate everything. That's why the withdrawal agreement contains issues that normally would fall under member states' competence, with, rights of residents and these kind of things. And since it said it's a catch-all for this area, you can have a union-only agreement in all areas, be it national competence or not, under normal circumstances. I think this is a good interpretation of Article 50, and this enabled us to deal with it really in a comprehensive manner. That's why I think Article 50 proved to be workable. And in my opinion, there are many other articles of the treaties that need urgent reform, and I would not put Article 50 in that category.
Are there other questions for me?
I don't know, maybe the European political community. The UK was not sure if they would participate, and then they will participate, and then they even want to host one of the next meetings. So they like the idea when they realized that this is something that basically enables them to work together, but also be a bit distant to it. But I mean, this is a very personal opinion, like with many ideas of President Macron. You never know what the real added value is, and you never know what the real outcome is. When you see the conference on the future of Europe was also not the most fantastic experience for many people. So I don't know. This some ideas he has then remains to be seen what comes out of it. But the UK is committed. Thank you.
Yeah, starting with citizens' rights of workers from the UK in the European Union and vice versa. The idea is to maintain their rights under EU free movement law as it was at the end of this transition period. So they can stay there, they can work there. It's also about professional qualifications, recognition. So the idea is to maintain the status as it were before the Brexit. About why is criminal law cooperation in and not civil law cooperation? I was not there at the time of negotiations. From what I hear, the cooperation is based on the Hague Conventions now. I guess one has seen more need for the criminal cooperation part because it would be really have left more of a gap there. About a dispute settlement. So the TCA is a public international law treaty, which there's no direct applicability as far as I know. I mean, it has many parts and many provisions, and one would have to analyze each and every provision, but there could be a direct applicability for the withdrawal agreement for the citizens' rights, I guess. From what I know is, I know just one case now before a UK court about citizens' rights and about residence permits, and it's brought by the so-called independent monitoring authority, which is set up under the withdrawal agreement, especially to monitor the situation and file such claims for all the workers that are there for their rights, actually. I guess this was the
All right, thank you very much. Two more questions online. Just turn on your microphone, please. We will, as I understand it, not see you on screen. We will just hear your voice. And please also briefly state who you are.
Okay, I could also do it for them. I mean, read out their questions.
Oh, okay, then, yeah.
Yes, so we have two questions in the chat. The first question is from Mr. Markus Frischhut. He thanks the speakers for their excellent contributions. And his question is, the TCA refers to democratic principles, to the rule of law, human rights, countering proliferation of weapons of mass destruction, and to the fight against climate change. And he points out that there are some similarities, but also new elements, climate change, in comparison to Article 2 TEU. And he asks both of the speakers if you could give us more insights on the process, which values have been selected here in the TCA and why, and on the relation to Article 2. Yeah. The second question is specifically directed to Ambassador Schusterschitz from Madame Katja Ziegler. She asks, could you say a bit more about the relationship between the Commission and the member states internally in the TCA negotiations? To what extent was there pushback from the part of the member states on specific issues, areas of the agreement? And did this determine the content of the TCA in any way, even though externally unity was strong? Thank you.
Please go ahead.
Yeah, thank you also for these questions. On the values of the TCA, honestly, I don't know, but maybe you know why it's different. On the internal workings between Commission and member states, that was not without friction. That's for sure. There were certain areas where member states had very strong national interests, and the Commission then had to somehow soften this when they discussed it with the UK. But of course, I would say the interest aggregation and the formulation of interest towards the UK was then done by the Commission. So we don't know how they framed certain things. That's the beauty of this single negotiator, that he then decides on how to frame issues. There was one issue in the TCA where frustration was high between member states and the Commission, and that was the area of fisheries. In fisheries, and I'm now the ambassador to Coreper 1, so we have the Agri-Fish Councils in October and December devoted to fisheries, and this is a very ugly area, I must say, with stinky backroom deals and so on. So it's not a nice area, I must say. And there, this is also one of the articles that I would reform before I would reform Article 50. And here, one of the principles that we had was no cherry picking. So the UK either participates in the internal market totally or they don't. And you have the 4 fundamental freedoms and they go together. And this was very strong, and the UK always wanted to have more on financial services, more on this area, more on that, but less on this. And they wanted to have free movement of capital, but they didn't want to have free movement of persons, these kind of things. And there's no, you can't have cherry picking. And then we came, but fisheries is a different area. There we want cherry picking. We want full access to UK waters, and nothing should change for our fishermen. And the Commission then said, guys, this is not going to work. So we can't prevent the UK from demanding cherry picking and then cherry picking ourselves. And here the fisheries nations, and when it comes to fishes, they get very loud and demanding very quickly. And there was a big problem between the Commission and the member states on the area of fisheries. And this was also then one of the most contentious issues until the last moment, because the UK said very clearly, no, we want the reduction in fisheries rights. That's why there is a very complicated system in the TCA now on how fisheries will be treated. And here Barnier even publicly complained about the fisheries nations, that they really make his life very difficult.
No especially interesting insights in the how this list of values came together. I guess, I mean, the UK and the European Union share definitely many values and maybe more values than with other partners of TCAs. So I guess climate change was undisputed, I would say, as a common value.
Okay, with that, I thank the speakers for your excellent presentations, contributions to the discussion. I thank you for your questions, and I close the first panel, and I suggest we reconvene with just a little delay at 5 past the hour. So we shorten the coffee break a little bit, but still try to start almost on time. Thank you very much for being here. See you for the second panel.